Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Friday, February 27th, 2026. We're on voting list number 5. We're going to vote on the withdrawns first. So that is Senate Bill 615 and Senate Bill 679. The motion is for a withdrawal. Favorable. Second, it's been favored. Is everyone okay being recorded in the affirmative? Excellent. All right. Let's now go to Senate Bill, Jamie, are you ready for Senate Bill 360?
Thank you, Mr. Chairman. Senate Bill 360 repeals a prohibition against intentional infliction of bodily harm, permanent disability, or death on an animal owned or used by law enforcement, except in the case of self-defense. That is a felony of aggravated cruelty to animals. Instead, the bill establishes misdemeanors that more broadly prohibit specified intentional harm, harassment of, or interference with emergency response animals, which include a dog or horse used by a law enforcement unit. And 2 are subject to a broader range of criminal penalties for that conduct. A couple of the members had work grouped the issue after last week's voting session to address potential situations where infliction of injury may be justified if an animal was attacking. There's an amendment in your voting packet, and that is Amendment 603821. And it adds language to the end of the bill that provides first that nothing in the section may prohibit a defendant from asserting the defense of necessity to a charge of violating this section, and 2, that it is an affirmative defense to a charge of violating this section that the defendant acted reasonably to prevent physical harm resulting from a violation of the Maryland Use of Force statute under 3-572 of the Public Safety Article.
Chair, I would move the amendment and also offer thanks to council for sitting with us and workshopping this. I think the amendment as drafted is really thoughtful, and it crafts the solution that we were discussing in the prior voting session, making sure there was an exception for those limited circumstances. And the way that it's written, it does just that. So I do appreciate it.
So motion's been seconded. Is everyone okay with adopting the amendment? Now the bill is before you as amended. Discuss. Motions for a favorable with the amendment. It's been seconded. Is everyone okay being recorded in the affirmative? Senator West would like to be added as a co-sponsor. Senator Love would like to be added as a co-sponsor. Senator McKay would like to be added as a co-sponsor. Senator Charles would like to be added as a co-sponsor. I'll jump on too. Okay, cool. Jeff's gonna jump on, pile on. Everyone's all right. All right. Senator Sidnor?
Senator
No?
Wallstreger.
Oh, he's good. All right. Senator Wallstreger's on. Smith. All right.
Do you mean to just, this is who I have.
All right. Is everyone okay being recorded in the affirmative with the amendment? All right. Senate Bill 360 with the amendments passes unanimously. All right. Jamie, we'll stick with you. It's 533, Senate Bill 533.
Thank you, Mr. Chair. Senate Bill 533 alters the annual salary of the Frederick County Sheriff by establishing that the salary is $125,000 for calendar 2026, $175,000 for calendar 2027, and for calendar 28 and beyond equivalent to 82.5% of the Frederick County State's Attorney's annual salary, including any increments and salary adjustments as specified in the bill. Any change in salary of the state's attorney during the sheriff's term of office may not apply during the sheriff's current term of office, but the changed rate does take effect at the beginning of the next term. Pursuant to constitutional requirements, the salary structure specified in the bill takes effect at the beginning of the next term of office, and we do have a delegation letter. Let me just confirm.
Yeah, it's also on the force system.
We do have it. Okay. So we do have a delegation letter.
Correct.
Thank you, Mr. Chair. Senate Bill 294 prohibits on notice that a case filing or a record includes identifying information about a victim of sexual assault or stalking, that the court or a party in a criminal or juvenile delinquency case may not disclose or allow inspection of the electronic or paper filings or records to anyone other than the victim, victim's representative, unless all identifying information is redacted. The bill also includes a limited exception based on a court's finding of good cause by clear and convincing evidence. Further, on written request of a victim of sexual assault or stalking, the court must redact identifying information relating to the victim from the existing file or record. Under the bill, a victim of sexual assault means an alleged victim of sexually assaultive behavior as defined in the code, or a crime specified in Title III, Subtitle 11, which applies to human and marriage trafficking. A victim of stalking means an alleged victim of stalking as defined in 3802 of the criminal law article. There is one amendment in your voting packet. This is Amendment 523923 for SB 294. The amendment provides for petition to be filed by a health occupations board to obtain the unredacted documents. And after a petition is filed, all parties to the case would receive notice of the petition, and the state's attorney would be responsible for notifying each victim in the case that a petition had been filed. There's also specified information that would need to be provided to the victim, but unless the victim in the case objects, the bill provides that an investigation or other disciplinary action taken by a health occupation board against a defendant in accordance with the provision of the health occupations article is good cause to allow disclosure or inspection of the unredacted filing or record. Further provides that a health occupations board that obtains a filing or record may not publicly disclose the record or filing.
Do you want to move the amendment? Okay, it's been seconded. All right. Now the bill's before you as amended. Discussion. It's a motion for favorable. It's been seconded. Sorry, we're on Senate Bill 294. Okay. Is everyone okay being recorded in the affirmative with the amendment? All right, Senate Bill 294 with the amendment passes unanimously.
Thank you. Thank you, Mr. Chair. Senate Bill 177 prohibits a person acting alone or with others from intentionally preventing another from entering or exiting a religious facility by physically detaining the other or obstructing, impeding, or hindering the other's passage. Violators are guilty of a misdemeanor and subject to imprisonment for up to 90 days and/or a fine of up to $1,000. The bill's provisions specifically do not prohibit speech, and the bill does not apply to, one, the chief executive officer of a religious facility or their designee, or to an agent of the religious facility or a law enforcement officer. There is one amendment in your voting packet. That is Amendment 413927/1. The amendment strikes provisions of the bill and instead provides new language that a person may not use force, threat of force, or physical obstruction to interfere with or physically injure with another while the other is lawfully exercising or attempting to lawfully exercise the First Amendment right of religious freedom at a place of religious worship. A person who violates this section is guilty of a misdemeanor and on conviction is subject to imprisonment not exceeding 90 days and/or a fine of not exceeding $1,000.
The amendment was Senator Waldstreicher's amendment. I think it's a good one. I move the adoption of the amendment.
Actually, hold on. There's been a second for the amendment. Is everyone okay adopting the amendment? Yeah. Discussing the bill before. All right, great. Senator.
And just for the record, we're talking use of force, threat of force. We're not necessarily talking somebody yelling at somebody. Is that correct?
It says physical obstruction.
Right. I'm just making certain that's clear.
Yep.
Okay, why are you looking at that, Jamie?
Sorry, this is just my thinking phase.
So, yeah, I don't read force or threat of force, obviously, would just be somebody, could be somebody screaming at somebody, right? Like that, if they are threatening to use force. If they're saying, I mean, a threat would be verbal. But that's
It's not necessarily expressing a disapproval.
Yeah, I don't read force or threat of force as just saying I don't like what you're doing.
Okay.
Yeah.
Thank you.
All right, there's been a motion for a favorable. It's been seconded. Further discussions, everyone okay being recorded in the affirmative with the amendment? All right, so Senate Bill 177 with the amendment passes unanimously.
Senate Bill 463 repeals the authority of a municipality to prohibit vagrancy.
Yeah,
that this bill is much simpler than my United Methodist bill, which I don't see on the list. but I'm sure at some point it's coming. I think because our chairman is United Methodist. Anyway, okay, move favorable.
And a motion for favorable has been seconded. Is everyone okay being recorded in the affirmative? You're not. All right. Senator McKay's down.
What's the?
This is Senate Bill 463.
For what, sir?
463.
463. What do you say?
Take your snacks and be done.
Just built in the city of Cumberland, and the state helped rebuild all that. We ended up doing the downtown mall, and we had people then deciding that they were going to camp out on the brand-new downtown mall, invested millions, $10 to $12 million of investment, and we had people giving out tents, and then they were then. So I understand the problem, I really do, but to allow them, the municipalities not to do that is just not, that's not compassionate, because that's not where they need to be for their services. So, with all due respect, I have to vote nay, sir. I understand.
All right, passes 8-2. Okay. All right, let's go to Senate Bill. Shamar, we'll stay with you. 277.
Senate Bill 277 expands the basis upon which a determination can be made that a given county is the proper venue for administrative or judicial probate of the estate of a decedent who is not domiciled in the United States. The bill also establishes that for purposes of the inheritance tax, which is imposed on property with a taxable situs in the state, the situs of intangible property is the domicile of the defendant. The bill's venue provisions apply to estates open on or after July 1st, 2026. The inheritance tax provisions apply to decedents dying on or after July 1st, 2026. There is an amendment in your packet. This is Amendment 653026/1, and that amendment addressed concerns of the registers of will and provides that, one, the venue for administrative probate for a decedent that was not domiciled in Maryland but resided in Maryland, venue is the county where the decedent last resided. Two, it provides that if the decedent was not domiciled and hadn't previously resided in Maryland, the petitioner can choose based on 5 options listed in the bill. And 3, provides that if none of those apply, the Register of Wills and Orphans Court or other governing entity determines the venue.
Thank you, Mr. Chair. I just want to know who's going to take all these bills next year.
I know. Do we have a motion? Oh, actually, for the amendment. Is everyone okay with that? All right, now the bill's before you as amended. This motion's for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right, Senate Bill 277 with the amendment passes unanimously. We'll now move on to Senate Bill 297.
Senate Bill 297 prohibits a motor vehicle manufacturer, distributor, or factory branch from taking an adverse action against a dealer for disclosing on the dealer's website that the advertised price of a vehicle is the manufacturer's minimum allowable advertised price, and that the dealer may offer a lower price for the vehicle. This does not apply to situations in which a dealer violates existing prohibitions related to deceptive advertising, advertising a vehicle without the intent to sell the vehicle as advertised, or any state or local law intended to protect the public.
All right, there's been a motion for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? So Senator West is down. You're up. All right. Okay, it's up. Yep. All right. Senate Bill 297 passes, what, 10-1? 10-1. All right, Shamar, we're going to go with Senate Bill 215.
Senate Bill 215 generally extends applicability of certain provisions related to local government personnel, trout stamps, and landlord remedies under tenant holding overactions to definitively include all members of the uniformed services. In addition to other clarifying and conforming changes, the bill also relocates the existing definition of a military protection order to the state government article. This was JPR secondary on this bill. Yes, they Triple E already voted on this bill. I don't know that it wasn't posted.
Discussion? Motion? Oh, hold on, Senator Henson.
Chair, it alters the tenant holdover process, and I know that when you can look at the DOD website and you can see if a person is active duty there. When including the Public Health Service and NOAA, do we know if they similarly have a searchable public database where a person could be in compliance with the requirement to check the box if the person is active duty? Okay.
I'm not sure. I would have to look into that, Senator.
Just briefly, if we could, to check on that. Thank you.
All right, so Senate Bill 531.
Thank you, Mr. Chair. The bill prohibits a law enforcement agency in interactions with a victim of sexually assaultive behavior from making a request for verbal acknowledgement to waive certain rights as otherwise specified in statute. Currently, statute prohibits a law enforcement agency from presenting a victim a form purporting to relieve the law enforcement agency of an obligation to the victim, or precluding or defining the scope of an investigation that the law enforcement agency would act on. There are no amendments to the bill.
All right. There's been a motion for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Yes. Right.
Then we'd have to amend it.
Favorable is amended, that's fine. You can, yes. Senator West would like to be a co-sponsor of the bill. Senator Henson would like to be a co-sponsor of the bill. Hold on one second. All right, so now the vote is for favorable as with the amendments. Is everyone okay? You're recorded in favor. All right. Senate Bill 531 passes with the amendments passes unanimously.
Senate Bill 352 requires the Motor Vehicle Administration to develop and make available an old line plate for certain vehicles. An old line plate must resemble the registration plate issued by the state in 1911. The bill establishes requirements and limitations related to the issuance through auction and transfer of such plates. Any fees collected under the program must be used to recover the administration's costs, with the excess credited to the Transportation Trust Fund.
So, is there an amendment?
There is an amendment in your packet. It's number 503821/1, and it simply amends the title of the program to avoid some potential confusion with an existing business that exists.
Move the amendment.
All right, the amendment has been moved. Is there a second? It's been seconded. Is everyone okay adopting the amendment? Okay, now the bill, sorry, Senator Sidnor.
I'm just wondering if the sponsor of the legislation, did you have a conversation with the business and they're fine with how it was retitled? Were you a part of the conversation with the business to ensure that they were all right with the retitling of this program?
No, I haven't had any conversation personally.
Are we?
Said in the hearing that they were okay.
They said they're okay, right?
No, what, so.
Yeah, that's okay, they're fine.
But yeah, I believe witnesses had stated during the hearing that they'd spoken to, I think it's a culinary blog called The Old Line Plates or something to that effect. And I believe the testimony was that they'd spoken to them and that just simply adding the word license plate, to the title was going to be enough to avoid any confusion.
Now the bill is before you as amended. Motions for favorable, it's been second with the amendment. Do you still have another question? I'm sorry. You sure? Yes, sorry, my apologies. Yeah.
That's okay, sir. So there was a testimony from Chesapeake Bay Trust, also Ag that Foundation, MAIF, and was there any consideration for some of their testimony that cutting into the revenue? I had a discussion that maybe we could do some form of a carve out for them or some kind of language that the intent is not to compete with these.
I think, I know they wanted an expiration to, you let me know if I'm mischaracterizing this, but I know they wanted an expiration to the program, but since it's an auction, it'll.
Well, I don't think that, I know that they talked about an expiration, sir, if I may, but I also, we were kind of spitballing, was there a way to either send a percentage of the money to those two? Because if it's not about the money, it's about having the tag, and I didn't know if there was any consideration for that. Even if it was, I don't know. If you're going to sell these for millions of dollars, I'm not sure the percentage needs to be that large, but is there any consideration for that? That's all.
Thank you. Josh, in the bill itself, does it say where the money goes, or does it just go back to the Transportation Trust Fund?
Yes. The MVA can cover their costs and the rest goes to the TTF.
I mean, and this is an auction? This is an auction, so there's is it a minimum, is there a floor where it starts from, or is it just they're only offering so many of them and?
Only offering so many of them.
Yeah, I don't think there's a minimum price or a maximum price in the bill.
Do we know what the amount is, or is it just time frame?
It's just time frame. I think there may be testimony, and Grayson, if there's testimony from other states that have done this, with the revenue they've drawn.
I mean, I don't imagine it's going to be crazy, but. Process. Instead of fee with the auctions, there's it's more similar to
An amendment that says minus the administrative charges of doing that kind of stuff, the money is then split between two MAFE and Bay tags. Is that a compromise? X for what they cost? Correct.
What do you want to do?
Can we? Yeah.
But I don't think we should tap into pulling too much money from this. It's going to the Transportation Trust Fund. The Bay they get a significant amount of money from their tags. Everybody, the other folks, the ag folks get a significant amount of money towards their tags.
They're just afraid of the competition. Like that's eating into it.
They're afraid that it cuts into the option. So,
As other bills come
yeah, so is there
forward.
a consideration that of the remaining balance of after the NBA pays their fees, like 50% goes to
25% there,
25,
Jeff?
Yeah, I know
25 goes to the.
there's some amendments in the House that are looking at that. I think we should pass it as is, and then we can have a discussion with the House members when it comes to how we address it.
But we set the trend here.
Yeah.
So like if we do it here, they would have to bring theirs after hours.
I think they already voted theirs out in the House. And we'll, you know, I know you want to.
Have they?
They did not move it out yet? I thought they voted it out. Okay.
We'd be open to of the remaining balance, 50% goes to DPF, 25.
No, 50% no.
No,
25.
no, 50% goes to the TTF.
Oh, yeah.
And 25, the remaining 50% is split between the Chesapeake Bay Trust and the ag tag.
Okay, I could do that, yeah. I thought you meant 50,
I
yeah.
mean, 50% goes to DPF, 25 to 25, the remaining goes to ag and pay.
I could do that.
Is that amenable? Do that?
You were fine with that?
I'm fine with it.
Yeah.
Okay, so we can do the amendment, but it's gonna be a little bit more complicated, so we have to hold it, just to get the amendment drafted, and then we'll vote it on the next list. Is everyone okay with that?
Thank you for your consideration. For the record, I am on the board. Said that in the hearing.
Yeah, got it.
Heard that here.
Full disclosure.
So then you still vote for it?
All right,
Yeah.
so.
As long as I declare that.
Yes.
Keep the amendment on there. Let's, Senate Bill Shamari, move 222.
Senate Bill 222 specifies certain requirements for an individual to be appointed by a court as a custody evaluator. The bill also prohibits a court from ordering the cost of an assessment to be paid in whole or in part by a party without giving the parties notice and an opportunity to object. The bill takes effect July 1st, 2026.
There's been a motion for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right, 222, everyone's good? First page.
Can I be added as a sponsor, co-sponsor, please?
Yeah, I'll also be on a sponsor. Senator Wallstreicher, Senator Smith, co-sponsors.
Thank you, Sam. Favorable with amendments now.
Favorable with amendments, yep, unanimously.
So no. Take it off. Not a co-sponsor. Oh, okay.
No, he said Ray Beth was gonna get big kids. So,
Oh, man.
Senate Bill 322 alters the circumstances under which an individual is disqualified from jury service. The bill repeals a provision that disqualifies an individual who has previously received a sentence of imprisonment for more than 1 year. Instead, an individual is not qualified for jury service if the individual has been convicted of a crime punishable by imprisonment exceeding 1 year and is currently serving the sentence imposed for the conviction, including a term of parole or probation. The bill also disqualifies an individual for jury service if the individual was convicted of a crime involving or related to perjury, witness intimidation, jury intimidation, or a crime under Title 8 of the criminal law article, fraud and related crimes. Finally, the bill repeals a provision providing that an individual with a disqualifying conviction who has been pardoned qualifies for jury service.
I just want to note for the committee that we've passed this bill before in the exact form in which it is now. Everyone deserves to sit on a jury. The exceptions that we have carved out, obviously, perjury and, jury tampering are the appropriate exceptions to that rule. People deserve a jury of their peers, and that includes folks in our community who may have had unrelated criminal convictions. So I'm glad we passed this in previous years. I'm proud to vote for it again, and I'd move favorable.
It's been a motion for favorable. It's been seconded. Do we need a roll call on that, or is everyone? All right, so Folden is down. Okay, you're up. Okay. West, are you good? Okay. Just had one. All right. Good work. All right, so we're going to go 634, which is on the last page. And then, Shamari, we're going to come back to you with, no, actually, 366, but that's you there. All right, go ahead, Jamie.
Senate Bill 634 adds a violation of Section 3708 of the criminal law article, which is a threat against a state or local official, to the list of offenses that the state prosecutor may investigate if committed against a judge or a judge-elect. There was a note in my file that the judiciary was going to provide some information on the number of threats that they had been receiving. They did that, and there's a chart in your voting packet. Reads JTMC threats 2024 to 2025, and it outlines total threats, incidents of arrest, and incidents of charges. It's broken out by who the threats were against.
All right, there's been a motion for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right, Senate Bill 634 passes unanimously.
What number? I'm sorry.
Senate Bill 544.
Senate Bill 544 establishes a minimum adequate security standard for courtroom security at all courthouse facilities in the state. Any entity responsible for providing courthouse security must use best efforts to meet the minimum standards for courtroom security. Certain standards are applicable beginning July 1st, 2027, with additional standards beginning July 1st, 2029. The bill requires a court security officer to meet the qualifications for a special police officer as defined in Section 3-301 of the Public Safety article.
All right, some motions for favorable. It's been seconded. Senator Sidnor has a question.
I remember the Baltimore City sheriffs coming out in opposition. Do you know if there have been any conversations around, I guess, their concerns?
Oh, I'm sorry. I'm sorry, Senator.
Do you know if there have been any conversations around the concerns that the sheriffs are raising?
That who raised?
Baltimore City sheriffs?
I don't know if there have been any conversations. I didn't see any. The only unfavorable testimony was from Maryland Association of Counties.
Right, I thought they came in favorable with amendments. Right.
I'm not aware of any conversations that have been had.
Thank you.
I don't know the sponsor made any. $544.
Mako? So I was just, and that was my question, and I believe Senator McKay just asked the same thing. And no,
I'll just tell you that my concern was the smaller, more rural counties and what the staffing level is going to require. It's going to be more difficult for them to fund that. So we should probably get a more definitive answer from both those sources on the cost that's estimated.
well, then that's fine.
And I would note that it is aspirational, and there's no funding mandates.
So it's a bill that does. Requires nothing.
Use best efforts to meet minimum security standards.
Use best effort, okay.
Move favorable. Second. We're gonna move it. What? We're gonna move it.
There's been a motion for a favorable. It's been seconded. Do we need a roll call, or is everyone okay being recorded in the affirmative? Mike's down.
Yes, this would not be appropriate.
It's a, yeah. Okay. So then we're going to go into Senate Bill 540.
Senate Bill 540 prohibits on the grounds of a courthouse or a correctional facility, a private home detention monitoring agency, or its agent, an employee of a courthouse or an employee of a correctional facility from approaching, enticing, or inviting a person to use the services of a specific home detention monitoring agency, distributing, displaying, or wearing an item that advertises the services of an agency, or otherwise soliciting business for an agency.
So motion for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative on Senate Bill 540? Yes. Right. Senate Bill 540 passes unanimously. We're holding that. Senate Bill 366.
Senate Bill 366 establishes the Intelligent Speed Assistance System Pilot Program, which must be administered by the Motor Vehicle Administration. The bill requires an individual to participate in the program if the individual has accumulated points in an amount that would result in a suspension or revocation of their driver's license under specified provisions of state law. Generally, an individual must be a participant for 1 year. The bill establishes rules and procedures for program participation and requires the administration to adopt regulations, including requirements that a participant operate a motor vehicle equipped with an ISA system in a safe manner as determined by the MVA. There is an amendment in your packet. It's number 533925. It adds to the bill some requirements related to data privacy. So generally, the amendment would require the MVA or any vendor it contracts with to delete data within 30 days. It specifies the purposes for which data may be retained or shared, and it prohibits selling data for any purpose. Again, all those data privacy provisions apply to the administration as well as any vendor that it contracts with.
Move the amendment. All right. Is everyone okay adopting the amendment? All right, now the bill's before you as amended. Senator Sidnor has a question.
Just for the record, well, I remember it being said that there's some sort of a law that's in place that says that I guess you have cars or something can't be no more than, okay, it would have to be more than 10 miles over the speed limit. You remember?
Yeah, I believe that's the case. And under the bill, NBA, kind of through its program regulations, would probably say, that the governor has to cap you at, 11 miles or something like that.
Thank you very much.
There's been a motion for favorable with the amendment. It's been seconded. Is everyone okay being recorded in the affirmative? Okay. Senate bill. Hold on. It's 366 with the amendments passes unanimously. All right, so that's Senate Bill, that's Shamari, it's 477.
Senate Bill 477, subject to specified exceptions, establishes a statute of limitations for a civil action for damages against a person for an alleged act or omission related to the performance, review, supervision, or management of a real estate appraisal, regardless of whether the appraisal is in connection with a federally related transaction. A civil action to which the bill applies must be filed within the earlier of 2 years after the date the complainant knew or reasonably should have known of the act or omission, or 4 years after the date when the performance, review, supervision, or management of an appraisal, as applicable, was provided or should have been provided. The bill applies prospectively only and may not be applied or interpreted to have any effect on or application to any cause of action accruing before the bill's October 1st effective date.
I have a mall in my district that, never mind, just kidding. I was getting you back, boy.
Bill that we discussed in committee that when I brought up the issue of appraisal bias in the black community and all of our homes being appraised at recklessly lower amounts than other communities. And by removing the statute of limitations, the harm that it will inflict on black communities and homes within our neighborhoods, I just could not in good conscience vote for this bill. I'm not even sure how it even made it to the voting list, but needless to say, it's here, but I can't in good judgment support this.
I'm just trying to, go. Yeah, I mean, so so you're saying that, because who is doing when you're selling your house, you get the buyer is the one that's going to do the appraisal. And then, so this bill, you're saying that if you
remove the statute of limitations,
yeah,
or if you add a statute of limitations, so that the appraiser will not be held liable after a certain period of time, you don't typically know when you're, until you're either selling your house, when you bought the house, or when some study is done or something happens and you realize that your house was impacted by appraisal bias. It's not something that is internally known, but if we put a 5-year statute of limitations in place, by the time it gets there, you'll have no idea, no recourse to come back and address the situation.
Good. Senator McGinn.
I was going to say, right now, appraisals, they have to keep their paperwork, all that kind of stuff, up to 5 years. So I understand the concern where we're coming, and we're willing to come up with some form of a amendment. There are some states that have that in consideration. So, I mean,
And you know, my good friend here, you know, I appreciate him, but in terms of the appraisers, like I said, it's not blind to society. There was an entire study done by the Brookings Institution on appraisal bias and the impact on the black community. Billions of dollars have been lost in black neighborhoods across this country. Redlining is very real. When you look at how SDET assesses and appraises homes in the black community, or in the communities of Maryland as a whole, it's very specific. The closer your home is to land, to water, the more valuable it is. The closer your home is to an urban center, the more valuable it is. But when you come into Prince George's County and you look at our homes that sit there on the National Harbor and you appraise that in comparison to other jurisdictions on water, they're surpassing our communities. When you look at our homes that are next to Washington, D.C., the largest urban center, and you look at how Suitland and Capitol Heights homes are being appraised in comparison to homes in Montgomery County, our communities are being appraised differently. People are literally going into their homes and putting white pictures up on the walls in their house, whitewashing their houses just so that they can get some level of decency and a higher amount of appraisal in their houses. So for me, like I said, 5 years, you just don't know what you're up against. You don't know the nuance of the appraisal bias issue that's happening in your household, to your house.
Who's committee handling this one? Who's the counsel?
That's me.
Shamari, what is the law right now, or what is the recourse right now for a homeowner who pays for an appraisal and they think it's unfair?
So right now, they can file a civil action. That would probably be governed by the general statute of limitations of 3 years from discovery.
So this actually would extend that and be compliant with their requirement to store the files? Or store the appraisals that, like, they're required to hold on to their appraisals for 5 years?
The bill allows it. The bill says that after 2 years, when it should have been discovered. So I think it lowers the general statute of limitations to 2, but it's up to 4 years from the time the appraisal was done. So whichever is the earlier of the 2. And so if you don't discover it within 4 years.
So it does extend it from normal, because normally you said it'd be 3.
It shortens it to 2.
Okay.
4 years is the max. So from once the appraisal is done, even if you don't discover it. So if an appraisal is done and then 5 years have passed, you can't file a cause of action against the appraiser after 4 years under the bill.
Currently?
No, this is under the bill.
So currently, it's after 3 years?
Currently, it's after 3 years of discovery. So presumably, if, after 20 years of the appraisal, you could still file under current law.
But the discovery would be that when you were provided with the document.
If you discover the basis of the civil action, that's when it's discovered. Okay. Under current law.
Okay.
I think we have an idea for an amendment to carve out. Wait for it here. Okay.
From the beginning,
Yeah, got it.
we can work with those years.
Just carve it out.
Yeah. All right, so we'll hold. All right. Yeah, no, that's not, Yeah, we can do that one. Senator James. All right, we'll do Senate Bill 447.
Authorizes the Department of Human Services to, on a request, disclose a report or record concerning child abuse or neglect to one, the administrator of a child care center operated by or on behalf of a unit of state or local government or in a state-occupied building as specified. Two, the coach, team administrator, or manager of a youth sports program for recreational athletic competition or instruction for participants who are minors. And three, the administrator of other appropriate personnel of any organization that provides adult supervision or care and control of children. The bill also makes a corrective change in statute in reference to the Juvenile Justice Monitoring Unit within the Office of the Correctional Ombudsman.
The question, is it saying that the new categories listed in the bill, they would be mandated reporters?
No, it's saying that a report concerning child, oh, I see what you're saying. If it's making those people mandatory reporters. I don't believe that's the intent of the bill. My reading is under 1202C, a report or record concerning child abuse or neglect may be disclosed on request to the people listed in paragraph 1, and then the bill adds paragraph 2, subparagraph 2 through 4, may be disclosed by the Department of Human Services to the administrator of a child care center operated by or on behalf of a unit of state or local government, et cetera, the coach, team administrator, or manager of the youth sports program, and the administrator or other appropriate personnel. I don't think that makes them into mandatory reporters unless they otherwise would be under current law.
Thank you. Thanks.
It's your pleasure. It's been a motion for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative for Senate Bill 447? All right, Senate Bill 447 passes unanimously. We're now going to go on to Senate Bill 776.
Senate Bill 776 establishes the Commission on the House of Reformation and Instruction for Colored Children to be staffed by the Office of the Attorney General. The purpose of the commission is to research the history, operations, and resident deaths at the House, to provide a complete and public accounting of the children who died and were buried on the grounds, to promote healing and reconciliation through truth-telling, acknowledgement, and recommendations for systemic reform, and ensure descendant and community voice throughout the investigation and reconciliation process. There is an amendment in your packet. It is number 453823/1. The amendment adds the Department of Human Services and the State Superintendent of Schools to the commission. It clarifies the required qualifications of some of the Attorney General's appointments to the commission, and it requires that the commission, to the extent practicable and consistent with state and federal law, contract with Maryland institutions and historically black colleges and universities.
Just like to adopt the amendment and then work from that. Is it okay with the amendment? Okay. Now the bill's before you as amended. Further discussion? Sure, Senator Henson.
When that time comes.
All right, we're back in. So we're,
Do the James bill?
yeah. All right, so we're now going to start off with Senate Bill 578.
Senate Bill 578 requires the Department of State Police to establish approved rates for tow companies involved in police-initiated towing and recovery of light-duty vehicles, which have a gross vehicle weight of 10,000 pounds or less.
There's nothing in Montgomery County.
No.
Okay, that's right.
There is an amendment in your packet, which is number 223928. This just provides a little bit more specificity on what the rates should be, which is specifically that they have to be 80% of the maximum rates for medium-duty towing, which is another, rate that the department currently sets. And the amendment also adds a couple responsibilities to the Committee on Rate Setting and Complaint Resolution for Police-Initiated Towing. They would have to relate on issues related to insurance for out-of-state vehicles and insurance for the costs of cleanup that, is involved with these kinds of towing procedures.
All right, so it's been moved, seconded. Now the bill's before you as amended. Further discussion. It's been a motion for favorable with the amendment. It's been seconded. Is everyone okay being recorded in the affirmative? Okay. Senate Bill 578 with the amendment passes.
Did not expect the committee to hold anything. I had no expectation of that. I appreciate it. Don't want anybody to think that I thought the committee should stop its work because I had stepped out to get some help. All right, thank you.
No, thank you. No, want to make sure you're here to vote for your bill. It's good. All right, we'll now move on to Senate Bill 323.
Senate Bill 323 repeals provisions which require juveniles charged with certain offenses to be automatically charged as adults. There is an amendment in your packet. It is number 383329/1. The amendment would restore certain offenses as automatic charging offenses. It would require that the Department of Juvenile Services intake officer authorize the temporary detention of children who are at least 16 years old and accused of possession of a handgun or a crime of violence. The amendment adds reporting requirements for the department, for the Governor's Office of Crime Prevention and Policy, and the Commission on Juvenile Justice Reform and Emerging and Best Practices. And finally, the amendment adds provisions from Senate Bill 296, which generally limit the circumstances under which a minor may be held, detained, or confined in an adult jail or correctional facility. Those provisions would go into effect October 1st, 2029. The rest of the bill would go into effect October 1st, 2026. I think there's a couple additional tweaks that will be made to the amendments.
Move the amendment.
Second.
Second. Okay, now the bill's before you as amended. Who's going to finish the amendments, Senator Folden?
So the additional amendments would be that the bill, as even with the amendment as currently drafted, would repeal auto charging for 14 and 15-year-olds who are accused of first-degree murder or first-degree rape or any attempt to commit those crimes. So the additional amendment would restore those as automatic charging offenses. They would also restore as automatic charging a violation of Section 5-203 of the Public Safety Article, which is possession of a short-barreled rifle or shotgun.
Move the amendments.
Movement's been made, some seconded. Okay, now the bill's before you as amended. Further discussions, Senator Folden.
Thank you, Mr. Chair. So my first concern that I want to point out on this, we're finally seeing, especially with the efforts of state's attorneys like Ivan Bates, we're seeing a change. We're just now finally seeing a change of juvenile criminal activity trending in the right direction. And once this body sees a change like that, their first opportunity is to, oh, well, let's remove more charging violations that would be in the face of an adult court initially. So I appreciate the body, or the move of removing the short barrel rifle. That was a concern of mine, but it also includes a shotgun. And a shotgun, you only have to be 18 years old to go and buy now. So a handgun, you have to be 21 to buy. And we are leaving, well, actually, I got to put the framework of this place first. So I need to put it on the record that, as I'm looking at the Open Meetings Act, I feel that our meeting earlier was in violation of the Open Meetings Act. We had too many members there in a private meeting. It was not recorded. It was not allowed for public discussion. I think that violates, I'm sorry?
I was not present.
I think that violates the spirit and intent of what good law is. It should be always open out in the public eye and for the public review. We violated that today. Having said that, when we are looking to move things and now remove automatic charging for those who are 16 and 17 that wear, carry, and transport a handgun, I have a concern about that. When we are removing the use of a machine gun for aggressive purposes, or is that on there? I might have the wrong one. Hold on. Is that stays on? Okay, that one stays on. My apologies. When we are doing the anything with a regulated firearm, handguns, we're not doing anything with that. We're allowing them to not go in front of an adult court for an adult offense. I appreciate the body's movement on the 14 and 15-year-olds with rape and murder, but this falls very short. And the reason I want to point this out to the body is I want to be clear that SB 323, once again, we are doing nothing for our victims and everything for our suspects in crime. Just like this week, when a murderer came in front of this board that murdered and executed my friend at 16 years old, he's out walking around with a second chance. My friend's not. He's dead. He doesn't get a second chance. And this guy has the nerve to come in here and want to talk about that the parole or probation system let him down. It's insulting. He executed a 16-year-old kid. Some of these, there's no fear by juveniles for consequences. We just saw this the other week in Baltimore with a juvenile that had an ankle monitoring bracelet on who tried to run over a police officer. There's no fear. Accountability matters. When we have an incident from January 17th of 2026, this year, 17-year-old in Prince George's County, arrested for the murder of a missing DC girl, teenager, 14. We're enabling the continuance of that behavior by not holding them accountable when things are preventable now. November 18th, 2024, a 14-year-old boy charged with attempted murder in connection with a shooting of a 15-year-old at Dunbar High School. Difference is he pulled the trigger, still had the gun. Access, availability, execution. We're one step away from bad judgment. We always want to talk about they haven't fully developed their brain and, oh my gosh, we need to do more to protect them. When you have access to a firearm that is loaded, and you have it in your possession, you are one split second away from having the opportunity to discharge it and killing someone. February 25th, 2026. Neighbors demand answers after 15-year-old arrested for a shooting in Middle River. 15-year-old suspect had a gun. Shot him. No one cares about that? No one's worried about that? No one thinks that having access to guns is not a precursor to everything I'm reading you right now? And I just did this, mind you, in the short time I walked out of that meeting and came here. This is how accessible this is. Think about your decisions you're making today. Police find an AR-15 style pistol hidden in teen's bedroom in Maryland. October 17, 2023, Frederick, Maryland. For armed robbery, police say it was an unregistered AR-15 style pistol with 2 fully loaded magazines without a serial number on it by a 16-year-old. Straight to juvenile opportunities, not being heard, accountable for the appropriate consequences. November 15, 2024, 17-year-old with a warrant. 17-year-old with a warrant in Gaithersburg for failing to appear. See, there's no consequences for these juveniles when they don't appear in court. You all created that. You gave them an out. There is no accountability for them to go as a juvenile. There's nothing requiring them to be there. We allowed that to happen. Members of this body did. On Friday, November 8th, 2024, at Rockville with a handgun and 250 suspected fentanyl pills, was stopped by the 4th District Special Assignment Team. Suspect jumps out of the back of the vehicle, pulled a loaded Glock 17 from his waistband. There's a picture of it if you want to see the gun. I don't know, these aren't fake. These aren't little pellet guns. These are what people use to die, that execute others. And look, there's drugs with it. Fentanyl, but we're not worried about fentanyl anymore. It's not on the front pages every day, right? We have Narcan.
No, it doesn't.
Exactly. Traffic stop leads to arrest of 2 teens with a firearm. April 4th, 2025, 16 and 17-year-old have been arrested and charged with multiple handgun charges with officers of the Montgomery County Police Department, 4th District Community Action Team. Found the rear passenger in possession of a loaded handgun. December 17th, 2025, 16-year-old boy caught with an assault rifle. This is your assault rifle. 16 years old. I don't know if that looks like something that a 16-year-old child that everybody wants to pretend is happening here, but these aren't childlike actions. These are adult actions that require adult consequences and accountability. January 27th, 26, a month ago, 2 juveniles charged with first-degree murder, fatally shooting in Somerset County. What's the difference here? They had access and opportunity. They had access, possession, and an opportunity. The opportunity presented itself. They killed. First-degree felony murder, second-degree murder. 16 and 17. The 2 victims suffered from an apparent gunshot wounds as they sat inside their 2026 Kia Seltos. Montgomery County, February 10th, 2026. 2 weeks ago. Not even. 16-year-old with possession of a gun following an assault that led to a double stabbing. I don't even know, can the 16-year-olds have a knife of any length? I don't know I'm asking for a friend. Stabbed a 16-year-old from Washington, D.C. and was with the suspects who robbed the teens and displayed a gun during the assault. Arrested in Montgomery County 2 weeks ago. 16-year-old, Montgomery County, faces 2 attempted murder charges at Wooten High School shooting. Age, access, opportunity. No accountability. If we stop them before this, we're prohibiting we are denying them the significance of the crime they are committing. Subject had a polymer 80 9mm handgun, was found late Monday night. Investigators said the gun was a ghost gun. I don't know. I thought ghost guns were illegal for anybody, but they had it. It's really weird to me. But that's a decision that they made to get it illegally, get an illegal gun that they're not allowed to possess without a permit
and then they do it through a ghost process. This should concern everybody here and your families and your communities. July 17th, 2025, a 16-year-old suspect in custody where shots were fired during a physical altercation that involved a group of 20 juveniles. Officers detained 7 juveniles between the ages of 11 and 15. Officers detained 7 individuals between the ages of 11 and 15 in Essex, Maryland. June 11th, 2025, 15-year-old charged with murder in Cambridge shooting. 15-year-old has been arrested and charged with the murder in connection of a fatal shooting in Cambridge on Sunday. Opportunity, execution. Possession, opportunity, execution. There's a theme here: possession, opportunity, execution. When I say execution, people are losing their lives. We're going to pull back the enforcement that's worked, that has changed and curbed the violence that this body is so proud of, but the first opportunity, you want to peel it back. 15-year-old shot a 23-year-old from Seaford, Delaware, Allison Ilian, was found lying outside the vehicle with gunshots to his head by a 15-year-old. 15-year-old's not even what we're talking about. We're talking about 16, 17-year-olds. And from a few years ago, a 16-year-old girl has died after she was shot Tuesday at Great Mills High School in St. Mary's County because she was shot by a 17-year-old student. Walked into school, possession, opportunity, execution. Killed her. What's the juvenile justice system doing for her? I keep seeing these letters coming in from the Office of the Public Defenders talking about 80% of these juveniles that are being arrested with guns are minorities, are black. Maybe what this body should be doing, yet they only comprise 30% of the population. We're not changing the race of the assailants. We're failing them before in these areas of concentrations of poverty before they ever get the gun because we're not there until after they have it. That's where this body fails our communities and fails areas of concentrations of poverty, of race that are put into these very difficult situations. This isn't about a race issue. It's about this body doing something that's meaningful on the front end of this in these communities where the concentration of poverty exists, that the access to these programs isn't helping them until they're met with law enforcement doing their job, holding a gun. And you all want to take that. You don't want to put it in place on the front end. All we do is react. Where's the proactivity? This body moving this, allowing 16 and 17-year-olds to move this bill without any adult consequences being there is shameful. And I appreciate you allowing me to express that, Mr. Chair.
Thank you very much, Senator. One thing, one thing I do agree with you with is that all of us are very much interested in public safety and ensuring that our justice system holds people accountable, but also ensures that people have a constructive path forward. The bill before you is the result of a lot of hard work, and I want to thank the committee for that work. The Department of Juvenile Services largely deals with this population that the bill deals with, except before, if they're auto-charged, they're going to go into the adult system where they will not have access to services, not have access to education. We're going to waste a lot of money, we're wasting a lot of money, a lot of time, and getting worse results. The bill before you corrects that. They're going to get services, they're going to get supports, we're going to save money, and you're going to have better public safety outcomes and better outcomes for the children who are unfortunately enmeshed and have become just as involved. I could not agree with the senator more that more needs to be done on the front end. We all strive to do that with various pieces of legislation that we've had before the body. There's been a motion for a favorable with the amendments. It's been seconded.
Co-sponsors too, if you want.
We also have co-sponsor requests.
Senators Brooks and Watson.
Senators Brooks and Senators Watson would like to be added on to the bill. Is everyone okay with that amendment? All right, we're going to give an opportunity. We're going to roll the vote, and we're going to have an opportunity for Senator Folden to explain his vote. I'm sorry, yes.
Something because it's important to me. I think the bill now is not going to eliminate auto charging for 14 or 15-year-olds who have committed or attempted to commit murder or rape. Is that is correct? Okay. All right. Okay. I might have.
Vice Chair Waldstreicher.
I'm a yes. And Mr. Chairman, if I could just have a moment to explain my vote. So this bill has been in for a number of years, and it's no secret that I've been a skeptic of this legislation. But three things have changed this year that have convinced me to vote yes, and I wanted to let you know what those three things are and why I'm voting yes. The first is, it's not my MO to criticize anyone, but I think it's fair to say that there was a lack of trust between the previous secretary and this committee, and me personally. And so the ability to wave children down into DJS with a secretary for whom we lack trust was anathema to me. And that's why I couldn't support the bill in previous years. The new secretary, I've spoke with at length, I know many of you have as well, has changed the culture of the department, has changed the policies of the department, and is committed not to an ideological vision, but to a vision of safety and rehabilitation that is operational each and every day in our community. And I appreciate that. And that allows me to trust that when we send these children now to her, that she will enact the appropriate policies to bring those kids back into our community in a way that is safe and rehabilitated. The second thing that's changed is, this bill has been under multiple sponsors over the years, and it's all of them are people I respect. But the chairman carried it this year and did an incredible job bringing everyone together to consensus or near consensus on this bill. And there were multiple opportunities for all of us to provide our input. That input was taken into consideration, integrated into the bill. And it's just a type of leadership, a consensus building that we hadn't seen before. And so I want to thank the chairman. That switch in sponsorship was deeply meaningful to the outcome of the bill. And then the third thing is, earlier today we voted for a bill related to the House of Reformation. And in previous years, this bill hadn't had the historical context that I think was necessary to pass this bill. The rank racism that we saw, that we've learned about, continues to infect our juvenile justice system. And knowing that history and being educated to that history and visiting the site was deeply meaningful to me and informed my position on this bill. So I do think there have been changes. I think those changes have been real, and that's why I'm voting yes on the bill. Thank you, Mr. Chairman.
Senator Charles. Sorry, Senator Sidnor. Sorry.
You look like I'm voting second. No, before I vote, I also wanted to say, and listening to the comments that have been made, certainly I think the examples that were put before us, I can't imagine that any of those acts would not have been prosecuted. This bill is about where the process starts, and I vote yes.
Senator West.
I'm going to vote yes. And let me just say, this bill's been very troublesome for some time, but I am persuaded that the 6 categories of offenses which are being taken out of the automatic charging are offenses which, based on the statistics, the data that we have, almost invariably are moved back from the adult court to the juvenile court. So all this bill does is allow a judge to make a decision up front quickly without waiting a year, which frequently happens when the cases are moved back to the juvenile court, to make a decision up front quickly whether or not the case will be tried in the juvenile court and the adult court. If he decides the case is going to go to the adult court, that's where it goes, and the public defender can always try to move back to the juvenile court. But more importantly, if the judge in these cases in the future decides to try the case in the juvenile court, the state's attorney has the right to try to move the case up to the adult court. Based on statistical information, it is highly unlikely that in these cases the state's attorney is going to succeed. So why don't we do the efficient thing and start them, let the judge make the decision, and if the judge decides to start the case in the juvenile court, the state's attorney still has the right to move it to the adult court. I just think we're going to save everybody a lot of time and expense, and we're going to save these juveniles who spend up to a year twiddling their fingers in limbo, waiting for a decision about whether the case is going to move back to the juvenile court, which almost invariably happens. We're going to get those people the services they need early on rather than a year after the fact. So that's why I'm voting yes.
Senator Muse.
No, I'm good. Oh, you mean that? Yeah. Oh, I'm sorry. Yes.
Senator Folden.
So I appreciate the opportunity to voice my opposition to this, and against, again, the procedural issues that I saw or that I feel we've done in violation. It's one of these times that I wish that the fruits of the poisonous tree actually applied to legislation, but it won't, because it'll still get ran through. The chairman made a comment, it was a very compelling comment, that we're getting better results. And we are getting better results. So why are we going to change it? But this is us changing it. With a brand new secretary coming in, and no disrespect to her, because I think she has a wonderful vision, but she's just hitting the ground. We need to continue to see these results and the effects of Ivan Bates and his office's diligent and appropriate prosecution of these cases, where a lot of them are happening in Baltimore. But not only him, but all the state's attorneys. You know, Scott Schellenberger has reached out. He's very upset because he was promised a meeting about this with the chair, and that meeting never happened. One of the most respected state's attorneys in the state, representing a large portion of our community, was promised a meeting. And I'm just going by what was just told to me. I'm not saying that it didn't happen or it wasn't offered. I can only go by what the man told me. He's an elected official, said he wasn't given the opportunity, although he was told he was going to have that sit down about it. And here we are, ramrodding another wonderful piece of legislation through that enables criminal activity for our juveniles. The court concern that I have is I heard about, extended times in the courts. There's a process in this, and these courts' inaction or lack of expediency is a matter within their system. Hold them accountable. Make them be more efficient. Stop letting them sit and prolong how long these juveniles are sitting in this facility for these serious offenses. But our solution is, no, we're going to continue to enable the behavior, let them go back to the juvenile system that they fear so much, by the way. Oh, my. They come out of there terrified, especially when they're ones toting guns. I think it's a shameful day that we have such a great movement in our state protecting our communities with a lot of documented things. I just pulled these up in not even 30 minutes. And there's more out there. I can read them more. I got them here. I just didn't have time to print them out. And where our effort is, we'll let them go to DJS. I hope it's never one of your family members or your loved ones that's approached by one of these, because my job is to protect my family, my community, and I want to be sure all of yours are safe. And with that, I will provide a resounding no.
Senator James.
May I make a comment? I want to thank the committee and the new secretary and her staff for working so diligently and providing information to us. And I echo the vice chairman's concerns about prior administrations. I also think extraordinarily important, and I could not be in the place I am now if the bill had not struck the language about first and second degree first-degree murder and first-degree rape, whether you're 14 or 15 or older, that is not appropriate for the bill itself. And also, the bill, as others have mentioned, has been greatly refined over the years. When I read all the state's attorneys' examples, they're all horrible. They're so horrifying. But I believe when we do not allow first-degree murder and rape to be, part of the bill, then the vast majority, I think almost all the cases I read from them, that's what they involve. So that's not going to happen. The other important parts of the bill are that a court will have to decide whether or not to release a juvenile in certain instances. There is an intractable group that my dear friend from Frederick County talked about, and that requires our unrelenting commitment to keep the public safe. But there's also a large population that is not being served by the system that we have today. And I would think that this committee and the courts and the prosecutors will do their job and not allow any juvenile to be released back into the public if they're a threat, but give our experts an opportunity to see if we can rehabilitate them. And I do expect my state's attorney, if he asks me for any help, I'll give it to him. If they need more resources to keep those juveniles in the courts, in the jail system and not avail themselves of any benefits here, I'm going to be very supportive. For all those reasons, I'm going to support the bill, and I thank everybody for working so hard.
Senator Henson.
Thank you. And thank you, Mr. Chairman, for your work on this bill and the diligence with bringing parties together, looking for consensus where it could be had, and then identifying those areas where we couldn't, but at least there was a discussion to be had. I do appreciate that. From my perspective, the bill is about public safety. And if we're looking at public safety, if you are 16 or 17 years old and you find yourself accused of one of these offenses, there probably is a lot that has gone wrong that led up to those days that led to the offense. And from my perspective, this bill gives the opportunity for a holistic solution, because there are a lot of days left, God willing, for a person who is 16 or 17 to still be here, to still be in society after they have served the time appropriate for the offense before them. And what we want to do is intervene early with meaningful solutions, and the juvenile system is just better suited for that. I also appreciate your acknowledgement and your commitment, Mr. Chair, to continuing to work to make sure that the juvenile system really gets the benefits that it should provide to children who are in its care and custody. So I know that for us as a committee, that work is not done. It was mentioned in some of the discussion today that perhaps we are failing children in Maryland, and we are not, as a body, actively taking steps to intervene in their life. And I would push back against that. I think we have put wraparound services in our schools. I think when I first came onto this committee, there was a different secretary. And one of my very first briefings in this committee was very diligent with the data that they requested and the way that they held accountability to the previous secretary, and the way that this committee has partnered with the new secretary to make sure that some of those changes are implemented. So I think our work here is not done. When we finish voting on this bill, we will continue to make sure that the benefits that we know are in the juvenile system are realized by young people who unfortunately find themselves in that system. I also want to thank you, Mr. Chair, for addressing the issue of what happens after adjudication when someone is housed in one of these facilities. If we're looking at the two different phases, one, we have to remember pre-adjudication, we have a system based on the presumption of innocence. So young people who come into contact with the system may or may not have committed the crime that they're accused of when they are being funneled into either an adult charge or a juvenile charge. If we look at those post-adjudication, this bill takes meaningful steps to make sure that that time has the opportunity for rehabilitation, because that truly should always be our North Star. So with that, I will be voting yes on this bill. Thank you.
Senator Love.
Thank you. I'm a yes on this bill, and I want to thank you, Mr. Chair, for all of your work on this bill. I also want to thank you for including 296 in this bill, where we house some of these children is incredibly important. The fact that we have young kids in solitary confinement in adult prisons is absolutely unacceptable, what we have heard about what happens to those kids. So it's very important that we address that, and I'm very glad that we did. I also want to pick up on something that Senator Henson said about what we've been doing. And I'm very proud of this General Assembly on addressing the totality. We passed the blueprint for Maryland's future. We addressed education, which is one of the most important things. We addressed, as Senator Henson said, wraparound services. We address housing to make sure that children get housing. We just had a conversation about inequality in appraisals. So we're addressing the issue of generational wealth. This body has done so much work, and there is still a lot more to be done, but we have taken a holistic approach to prevent people from being in situations that leads them to crimes, and to address what happens when they commit crimes. And I'm very proud of us, and I am in support of this bill. Thank you.
Senator McKay.
So I'm going to be a yay on this for the couple different reasons. We had looked at the data, 80+% are coming back. I am very, very satisfied with the new Secretary of DGS. And I think that is her policy. And really what we're doing is putting in statute so that if a future secretary is different, that policy just can't change without coming back here. Second of all, as I understand it, Judge still decides, state's attorneys will be present. And then third and final, I think it's important. We try to work very, very hard on each individual bill. And just like the body, there are many, many parts. And the hand doesn't do what the foot does, and the foot doesn't do what the hand does. But I think, Mr. Chairman, you have worked to address the issues of the majority voice on this and been very, very respectful. And I want to thank you for that. And I have to tell you that is the driving force of why I'm voting yes on this. Because you can ask all my 8 children. I don't always get what I want. But if we can work together as a family to put out the best product, I think we're there. And so I'm proud to vote yes, sir. So thank you.
Senator Charles.
I'm going to be voting yes on this bill as well, and I want to take the same opportunity to address the fact that you were willing to hear all concerns on the issue and was willing to work with everyone around the table to make this happen. And so thank you for removing and addressing the 14, 15-year-olds first-degree murder and first-degree rapes. You know, I think that is very critical that we remove that, and you did. And so I truly appreciate you for agreeing to address that issue. So thank you, and I vote yes.
Chairman Smith.
I'm voting yes, and just want to say thank you to the committee for the hard work. This is the best of the committee when we come together, work, exchange, a vigorous exchange of ideas to make the best work product possible, to help the most Marylanders possible, to create a better future for the most Marylanders possible. So I just want to say thank you very much for your work and for the vigorous exchange that occurred here today and for your vote. So I'll be proudly voting yes. So the bill passes with the amendments 10-1. That'll conclude our voting session and our work for the week. Thank you all very much. Have a great weekend.